Good morning to everyone. This is the fifth LUPC legal webinar event that we've run. Today is linked to Lot 1 on commercial law, and we're joined by Sam O'Callaghan from Capital Law. I will send out the details. Capital Law are highest ranked on the LUPC framework. That's available to all bar APUC members. APUC members that wish to utilise the services of Capital Law will need to do that in a compliant way, but won't see the framework inside HEC. The webinar today is in webinar mode, so there's a large number of people on the call, so we won't see your videos and your microphones are disabled. There are two buttons down the bottom. One is chat, one is Q&A. If you have any questions for Capital Law, head to the Q&A and put your question in there. If you see somebody else ask a question that you would like to know the answer of, please press the like or the thumbs up button and it will raise it up the rankings. And we do have a part of the presentation where there's a Q&A at the end with Sam. So ask questions. Yeah, so everything will be supplied after the event, so no need to write things down. And I will pass on to you, Sam. So good morning, Sam.
Brilliant. Good morning. Thank you very much, and thank you everyone for attending the presentation. So just a bit of background. I'm Sam. I'm a construction, energy and projects lawyer at Capital Law. We've got offices in Cardiff, London, and we've got a bit of a satellite office in Paris. But with the joys of construction energy, I do also lead the procurement offering for the firm. So get involved in all things procurement, which is an exciting bit of a legal change, hopefully coming up in the next couple of months to a year. We will have some new procurement law to deal with, which will hopefully be of interest to everyone. We're going to cover a bit of a general update today on where we are with procurement. We're going to look at some of the processes which you'll all be very familiar with, no doubt, as your day-to-day job is probably to do with procurement, I should imagine. And then we'll look at some of the sort of the processes, legal updates. We'll do a bit of a case law review then, because I appreciate for some on the call, the front end, what is the current procurement law will be second nature. Whereas the legal update might be a bit more interesting, hopefully, in terms of lessons learned. But what I will try and do as we go throughout is I'll try and bring in some of the trends in the market that I'm currently seeing, some of the things I'm seeing both contracting authorities, but also what I'm seeing bidders do, and hopefully that'll be a bit of a steer as to what we can all do for best practice and to try and minimise the dreaded successful challenge should a procurement process go wrong. So jumping straight in, because I've got quite a lot in the slides to cover, but we'll see where we get to. The UK procurement regime generally derived from international arrangements. So previously was mainly driven by EU. Now is going to be driven by a whole host of trade agreements, which means that we've got to procure contracts in a particular way in order to operate globally on the market. We can't sort of just favour our own domestic companies, because it will be to the detriment of our world partners is the general concept. But what that means is we've currently got quite a split of a procurement regime. So on the board, hopefully you can all see, is the current key pieces of legislation, and the ones you'll come across and regulations you'll probably come across most often is the public contract regulations, and that covers your general works and services. Concession contracts might be less frequent, but some of you on the call might have come across it or might use it frequently, but we'll come into exactly what that entails shortly. We've got utilities, so certain particular statutory undertakers or utility providers will be able to procure under a different set of regs. So we've got Ministry of Defence specific regs then, defence and security, where there's currently a plethora of cases going through the courts as to how defence procurement works. But I appreciate there's nobody from Ministry of Defence on the call today, so we'll jump over that one quickly. And then we've got NHS specific regulations. They all do roughly the same thing in a very different way, which is try and make sure that contracting authorities, so people who procure with public funding, do so in a way that is fair, transparent, and uses public money in a fair and transparent way for the benefit of the market. So looking specifically then as to the public contract regulations, this is the one that you will most likely come across. This is how most contracting authorities tend to procure their public services. Generally, you can, once you've decided what it is you're trying to procure, you've got some options then really as to how do you do it. Do you enter into a contract? Do you enter into a framework agreement with specific panel of buyers that you can call off in a particular set of rules or structures with a different variety of contracts at the back end? Or do you enter into a single contract with a single supplier? They're all dealt with under the public contract regulations. Now, the public contract regulations have been amended recently, but they are very small tweaks. So, for example, when we enter into trade agreements with Liechtenstein and Iceland, there's now a requirement for us to question abnormally low tenders when they come in, as opposed to a general, you have the ability to question abnormally low tenders. And that's just part of what will potentially happen now in a post-Brexit world, is we will have some of our niche procurement issues dealt with, basically driven by the global market. Now, for works, we've got a threshold of just over £5 million. That is now inclusive of VAT. And again, for services, then for sort of what we're looking at here in our central government, so we £213,000 again inclusive. And there is also the ability to call off the light touch regime, or to utilise light touch regime for educational services would be quite specific here. And what that does mean is you can avoid some of the key processes. So instead of having quite a driven process where we have to follow a set structure of notification and for example, open procedure, we can't negotiate. With a light touch regime, you've got far more flexibility as to how you are going to procure your services, which in theory means you should get greater resource there. There is always a difficulty really of what happens if we have a variety of different strands to a contract. So, what if a contract is works, what if a contract is services? The general rule of thumb is the majority rule of the contract is where you go down. So if you are looking at a construction contract, for example, where you're trying to procure the design and construction of a building, but that also includes some services on the tail end. For example, you might have security services bolted onto the tail end for a period of time. You can't procure that as one contract, as a services contract, because the majority of the contract would be works. So it's a quite a straightforward test that should help out. And the legal advice always from a cynical, risk-averse lawyer is, if ever you're in doubt, is to go with the higher threshold one, to make sure you are compliant. Then we've got concession contract regulations, and this tends not to be used as frequently as the public contract regulations for a good reason, really, and that is concessions are rarer in guise, and the main test really for what is a concession contract is the bottom bullet point on the board, which is you are letting a contract here where you are exposing the winner to what's called the vagaries of the market. So what we're basically saying is, to the market, we have an opportunity, and we will allow you to exploit this opportunity. And for that ability to exploit the opportunity, we're not guaranteeing anything, so that is your choice to run and manage the opportunity. So we've actually got, in the case law updates, one of the biggest procurement challenges ongoing in the UK, which is the challenge for the 4th national lottery licence. And that was done under a concession contract. And if you think about it, the general policy is we have a national lottery is established by law. All we're looking for is somebody to operate that lottery. And if everyone stops operating the lottery, then the person who provides the lottery would not make any money. But there's no guarantee or payment to that operator to allow them to function. It's purely an opportunity to run the lottery. And historically, you've got things like harbour masters. So we can say, well, we've got a port, we want somebody to run the harbour. We can't tell you the traffic, we can't guarantee any footfall, but we will allow you, harbour master, to set the rules and run the harbour, as long as you do so in a way that complies with whatever our contractual framework is. So how would this really apply sort of in the higher education or wider public sector. Whereas things like if you've got a space in your general facilities which you don't really know what to do with, you could, for example, go to the market. We've got a space, a coffee shop would be a good idea, or a supermarket would be a good idea. And you could do that as a concession. You can go, well, here's the space. We're not going to give you any money. We're not going to give you any guaranteed income, but we'll allow you this space for a period of time in accordance with this contract. And they can then, the winning bidder would be able to fit out the works, invest into it. So they're exposing themselves to the value of the market, because people might not attend to buy coffees, or might not attend to buy any goods in the shop. So it allows contracting authorities to get something exploited by the market without having to really share the financial burden. Another thing that might be quite useful is sort of kit hire or preferred suppliers for kits, or preferred suppliers for, dare I say it, graduation gowns. That might be something that a concession would be quite useful to go down. Both public contract regs and the concession regs comply with the exact same, what I call public law requirements. Is your three principles of procurement, really, is the big three that every single thing we do with procurement must comply with, which is that we treat everyone equally. So there's no discrimination between operators to the extent that we can. Now, there will always be some discrimination. If you are, for example, re-procuring a service that's ongoing, your incumbent will have some advantage. And really, it's on the contracting authority to mitigate, minimise, and in whatever way we can, ensure that competition is fair. So there will be some difficulties, but we must treat, to the extent we can, everyone equally. You've got to act transparently. So, and that runs through the whole procurement process. But really, when you're designing your procurement, when you're designing your ITT and your scoring criteria and your evaluation criteria, we're looking at specifically, how are we going to evaluate this tender? How are we going to score it? So transparency is very, very acute there, and proportionate. We must deal with everything in a proportionate manner. And all of this must be with the overriding objective that we're not narrowing competition down. And that is actually quite surprising, because it's quite easy when you start tweaking an ITT or tweaking something where the incumbent, for example, what they can provide, what they can deliver. If you are putting the scoring against something you are familiar with, to an extent, you might be artificially narrowing the competition down, because there might be some innovative solution that you're not aware of that might be better. So it is quite easy to trip over the proportionality test. The other driving factor, which is potentially subject to change should we see the new Procurement Act go through with royal assent, is the most economically advantageous tender is what we're after, which again makes sense, really. We are custodians to the extent we're publicly funded. We are custodians of the public purse when we're procuring. So we must ensure that we are getting the best value for money. Now, the reason why there is a potential difficulty with the most economically advantageous tender, as we're all aware, there are factors that are not necessarily economic that would also be advantageous to consider. So things like carbon reduction, as a very specific example. You could have a building solution, you want something built. A contractor could come in more expensive, but the reason they're more expensive is because they've got a significantly lower carbon footprint with the materials they're selecting, for example, or with their methodology. It could be sort of modern methods of constructing, so we're lowering down our carbon footprint. Now, realistically, does that mean we should score the tender better? Well, in our general ITTs as drafted, we have to comply with wherever we've drafted and wherever the law currently says, which is driving for economic. So potentially not. In England, you've got your social values, and themes, outcomes, and measurements. It tries to drive a social value calculation. If we try and drop the economic, there's an idea that you can score against something that's not particularly economic. In Crossing Wales, they've got the Future Generations Act. So there's and in Scotland, they've got something very similar as well. So jumping through the processes quite quickly.
Can I stop you in your flow there, Sam? Just
yeah,
Amy Shaw. Amy Shaw had a question for you, which was with regards to, can you remind Amy of the definition of proportionate that you just mentioned?
Yes, but proportionality, it comes down to the reasonableness test in public law. So it's just ensuring that when you're acting in a way that is reasonable to the market. In terms of definition is all derived through EU law right now, but going forward we'll be relying back on the sort of the judicial review proportionality test.
Okay.
Yeah, brilliant.
Thank you.
Yeah, no problem at all. Sorry, I didn't see the question. When I share my screen, I can't quite see the questions pop up, so I do apologise. With the processes then, so just jumping through the processes quite quickly, because again, I appreciate most people are going to be familiar with all of these as they currently are. But the sort of 1 and 2 in the table is the open and restricted procedure. And that's the one that basically you go, here's the contract, give us a price, for want of a better definition. Now, what that does mean is it does give contracting authorities quite a lot of control as to what the contract is. And it does give the market a bit of difficulty, really, because they can't engage necessarily in how in how they want the contract to look. So, for example, there could be something in the contract that they cannot procure against, or that prohibits them from complying with the actual contract at the end, but they might not necessarily be able to control that process. As a specific example, the professional indemnity insurance market took a massive hit after the Grenfell tragedy. And what that means is it's quite difficult for contractors to get professional indemnity insurance. So if we're saying, as part of our open and restricted procedure, you must have this level of insurance, it might be an impossibility for the contractors to have that insurance. For some of the contractors, others might be able to find other solutions around it. So what that does mean is we are making it difficult for the market to compete to some extent. So, and generally speaking, there is a habit for contracting authorities, and for good reason as well, for budget certainty, to make the contracts at the tail end very client or employer friendly. So what that means is the contractors will be taking a bit of a risk dump, and they'll price for that. So it just means your contracts will be a bit more expensive, but there will be some cost certainty from the tail end of it. Moving on then to competitive dialogue procedure, that is the full-blown big procurement process. And what that full-blown big procurement process tends to mean is a lengthy, you could be talking a year or two if you run a big procurement process. So you do want it to be a high-value contract. You do need to give a good reason for going down that route, as opposed to just an open or restricted procedure procurement. But what it does mean is you will get ultimately a negotiated solution that might be better placed. So it's very useful. I'm trying to think of a specific example. We ran a competitive dialogue procedure for a sort of a solution for recycling. I got to be careful what I'm saying here. For a recycling solution where there was no solution available in the market. So what you do is you tender for a solution and negotiate with what it could look like. Is there 3 sites for this recycling centre? Is it 2? Is it none? Is it one big one? What does transport look like? And it allows you to in a quite a structured way, negotiate with the different bidders, and as long as the process is set out in a particular way, you can score and act and treat everyone fairly there. Competitive procedure of negotiation there is sort of a hybrid between both open, restricted, and competitive procedure with negotiation and competitive dialogue procedure. Sorry. And what that does mean is you can have minimum requirements that contractors can't negotiate against. They can submit an initial tender, and then it's up to you whether you accept that initial tender or not. If you don't, you've then got the ability to negotiate with the tenderers there. Ones that use less frequency in innovation partnership tends to be used less frequency, whereas dynamic purchasing systems are used quite a lot for your sort of lower value, more everyday type purchase. Jumping on to legal update there. I think I'll just jump back because I think there's questions. Is that
there's one question in
questions
there. There's a question in there from Valeria. What is the criteria to choose the 5 suppliers for restricted tender? Is this true below and above thresholds?
So you've got your selection questionnaire, which is one of the PPNs have been updated at tail end of the presentation. We'll cover it, but there's a standard form question that allows you to go through the financials and get to a particular criteria that you've designed that allows you to limit those suppliers down. And the idea of restricted is you're asking for a supply that potentially hundreds of people could go for, which is why open procedure would be a bad idea. So the restricted procedure allows you to narrow it down. Those criteria, really, as long as you design them and put them up front and comply with your sort of Regulation 18 requirements, so treating everyone equally, transparently and proportionately, then you can add some additional queries onto that SQ to make it restrict down to 5 suppliers that you would find most helpful. And again, that's assuming you're not caught by the light touch regime as well. Is it true below and above threshold? Below threshold, you as long as you issue your contract notices, again, we'll come on to the PPNs at the end, because this position is changing slightly and potentially will change in the future. As long as you comply with your transparency requirements, below threshold is a bit more easier to just sort of award, as long as you hold whatever your internal procedure is for quotation. So, if you're going for a 10 grand procurement, you can get 3 quotes and you get around having to do something like that. Whereas above threshold, you have to make sure you do comply strictly with the requirements. So I hope that's answered the question. If there are any additional questions, please do feel free to email me at the end as well if I'm not covering them, if I'm not interpreting your question correctly. So I'll leave my contact details at the end of the slides.
No problem, Sam. Thank you.
Yeah, I think just on process as well. It's not on the slides, but I appreciate. I think some of the attendees might be very familiar with what we're covering. Others might not be as familiar, but I think it's worth just touching on the general concept of procurement and the regulations is to allow fair market competition. And what that does mean is once you've entered into a contract, you are restricted into what that contract does and how it operates. And so generally speaking, this shouldn't be modified. And that's probably a process point more than anything. Once you've entered the contract, you are in that particular contract, and the exemptions for the public contract regulations, Regulation 72, that sets out where you are allowed to deviate from the contract and where you are allowed to vary and modify it. Now, in the current market that we are in, there are obviously interest rate increases. There is a cost of living crisis, which means that material supplies, if the contract includes goods or works, materials are going up. They're fluctuating dramatically. And it means the supply chain is struggling to stay afloat in many instances. So we are in a bit of a difficulty here as to well, the contract says one thing, but the market is saying another. And there are mechanisms that allow you to vary the contract under Regulation 72. Now, when you are designing your procurement and market testing, contractors will come back with, we want fluctuation clauses, we want change of law risk to sit with the client. We want, they want a bit more of a risk share approach. If you don't have those in your contract, you might struggle under Regulation 72 to then later add them in. And again, just using examples, if you are let in a contract and once you award the contract or post procurement, the contractor decides to try and negotiate after award, and what they're negotiating is quite significant, it could have changed the outcome of the tender had you changed the contract to read in that particular way. So, for example, with no fluctuation clauses, people have added in risk when they're tendering, whereas the winning bidder then tries to post-contract negotiate. You can see why that might be seen as unfair then on the market. So is really thinking about, with new processes, is there ways we can feature-proof the contracts to allow us, I'm looking at Regulation 72(1)A, modifications that are allowed by the contract. That's our easiest route to vary the contract. Is there anything we can put in it that gives us the flexibility with the cost certainty we want? Otherwise, we'll be in a position where post-contract, we're looking at Reg 72 to go, well, can we do anything that is compliant? And, if we are making some of these amendments, we might need to notify the market we're making the amendments, which exposes the procurement process to challenge them. bit of an aside there. Legal update. So there's been some big legal updates, and there will be some big legal changes going forward for the education and procurement departments in particular. For any contracting authority or anyone that deals or passes through with public money. And the first one that sort of come into force just at the start of this year was the Subsidy Control Act, where we sort of kicked our state aid regime to the curb following Brexit, and we've come up with our own version of subsidy control. And for the past year or two, we've been operating on the basis of the Subsidy Control Bill, and it said in January is now coming to force of the Subsidy Control Act, and that has caused some difficulty with procurement to ensure that we're compliant. Whereas with state aid, it was more of a retrospective, or we just got to show after the event. With subsidy control, it's front loaded, so there might be questions of any of our funders, any grant funding or any pass-through funding, that we are complying with Subsidy Control Act requirements, or whether we need to consider them at all. A lot of subsidy control does stay generally, the principles are very similar, it's just worded differently. The other big change, Building Safety Act is coming in 2022. That again might cause some future difficulties with procurement and contractual structures, where we've got liability now extending 15 years for breaches of building regulations. Retrospectively, for any sort of defective cladding, you could claim back 30 years. So is one of the first of its kind legislations where we've got retrospective effect for 30 years of what is in effect a civil breach, a contractual breach, and this will have a big impact on everyone's estates. So you know, it generally hits on dwellings. So we're looking at accommodation. So it could be student accommodation, it could be any other staffing accommodation, depending on who's on the call. Really, is you know, hospitals tend to have staffing quarters. So it could hit on those, but it could also hit in the future onto any high rise and high risk buildings, which means that we will have to have building safety sort of factored throughout the process, which includes that procurement. So something to consider for any construction procurements you've got in the future. And then we got the Procurement Act, question mark, because we were expecting the Act to land by now. And is likely to land soon, but there will also be a 6-month period of implementation. So in reality, we won't be looking at really implementing the Act until 2024. But it's interesting. There's a lot of literature on what the Act will look like, and there's a lot of commentary on the bill, and there's a lot of commentary on what was going through and discussed in Hansard, so with the House of Lords and with the House of Commons. Very similar to how the Building Safety Act was structured, and the Building Safety Act was drafted in January 2022 in a particular way. When it was published then in April 2022, it was completely different. There was a whole host of changes that nobody had seen coming, that did cause some significant ripples to the market. And my concern is we might have something similar with the Procurement Act. So watch this space really. But what we do know, or what we anticipate knowing, looking at the bills and looking at all the commentaries coming down politically, is that the bill will at least include what's on the screen. So we should be looking at a single regulatory framework. Now, what that should mean is we no longer have things like the public contract regs, the concession regs, the defence regs, and the NHS regs. We should just have one set of regulatory framework, which should make it a bit easier in theory to instead of to consider which, for example, concession and public contract regs would be most relevant to this call. We'd have to consider which one to go down. It will just be one framework. In terms of expanding on key principles, there has been a lot of talk about the transparency obligations that have been issued through the PPNs. Whether or not they apply to your organisation on the call will depend on numerous things really, but the transparency obligations might include quite a significant administrative burden on contracting authorities, for example, to include contract notices on the end of the contract. So once you've hit practical completion, once the services are finished, to issue a notice to confirm what that contract looked like, how it operated, and ultimately the cost of the contract at the end. So not only are we issuing tender notices, we're then issuing contract award notices, we're then issuing post-contract award notices. Now that could be, again, quite a significant admin burden, but also it could also potentially start opening up some more challenges for what's happened between the contract award and ultimately the end of the contract. I mentioned dropping the E from meet and moving to MAT, so most advantageous tender. Again, there's quite a lot of good rationale behind doing something like that, but is whether there is just dropping the E is significant or not. We'll have to see how it's drafted into the Act when it is formally submitted. But again, it might allow things like scoring specific for decarbonising without a cost attributed to it, and just ensuring we do it in a way that is transparent so we can show everyone how it's going to be marked. Fewer but more flexible procedures. The general idea seems to be a sort of an open, restricted procedure, a competitive procedure, and just trying to limit it down instead of having 6 or 7 procedures. We try and get down to 2 or 3. What they look like and how they operate, again, we'll have to see, because I'm not too convinced what we've seen is what we'll get. Enhanced powers for contracting authorities is an interesting concept, and again, how this works in practice will be an interesting development for us all to look at. But the general idea is that we can, in theory, have KPIs in ongoing contracts. If a contractor fails a KPI, there could be a system where we, in effect, debar them for a procurement to say, well, you failed to perform your KPIs, therefore we're not allowing you to buy in this new contract for your previous poor performance. Now, there's got to be a limit on that, otherwise it's essentially just blacklisting a company for one bad project. But it might be interesting to see if that does improve service quality, or if it just simply improves, it drives up price even further. There's a potential for a procurement oversight regime. Right now, when we award a contract, there is our nervous period, really standstill, and sort of 30 days after our limitation period for challenge, we're a bit nervous as to if anyone challenges the procurement process, what's it going to look like? Where this new procurement regime might actually take out the challenge as the only issue we have, and it might now be a case that an independent body or ministers will have the opportunity to question, challenge, audit, review, whatever terms we land on, procurement bodies and procurement departments to ensure that they are complying with the procurement regulations. So it would be interesting to see again how that shapes and what it looks like. And again, there will be changes to modification provisions, which is currently our Reg 72, how do we modify and sort of vary contracts that are currently in place. And potentially new rules on KPIs. There you go. Lost my mouse. We're currently still awaiting the bill to keep going through, making its way around. And I appreciate there's lobbying groups, and people on this call might be part of those lobbying groups, in particularly for higher education, as to what those acts look like. In particular, things like the transparency obligations, how they apply, and also around some of the general social value obligations that have been sort of mooted around being included, and to whether, if anyone on the call's got charitable status as their contracting authority, is whether adding in things around driving social value has some difficulty and some sort of conflict with your charitable purpose, and whether the charity register would be too happy with you having a additional obligation for a purpose that is not your charitable purpose. So we'll have to see really what the bill looks like. I'm always a bit nervous saying it's going to be this, it's going to be that, because we don't know yet. So jumping on to what I would call the fun bit, but might not be the fun bit for everyone else, is the case law updates, really. So this is where we've got things that have not gone quite well, or maybe they have gone well, but an incumbent or challenger has decided to come forward and say, well, we don't think the procurement's gone particularly well for a variety of reasons. Now, the first one we'll look at is Consult and Connect, and I appreciate, again, most people on the call would probably be familiar with this case, as it's formed part a lot of legal updates and articles have been published around the case. But generally, what we're looking at here is an NHS commissioning group decided to run a joint procurement for, I think it was pagers and beepers for electronic communication, basically for GP surgery. So how does electronic communication work? You've got 3 separate contracting entities deciding to collaborate together into one procurement process. There were 2 suppliers really who had a good shot at getting the contract. One of the contracting entities used one supplier, one contracting entity used another, and the third didn't really have a solution that was working. So they decided, when they were considering, well, how are we going to procure this process, to hold a demonstration day where they would turn up and present what their product is, how this communication system would work for each of the GPs. And the 2 companies invited weren't actually aware that it was a scored demonstration day. They thought it was almost like a market engagement, what is the solutions on the market. But it turned out the 3 consortium NHS trusts had a scoring system where they decided which was best, which solution would work. And then once they decided which solution would work, they realized that the one contracting entity was already on a different framework that they could call off. So they decided to then call off that framework and award the contract to the winning bidder, to Consultant Connect's detriment. Now, Consultant Connect decided to challenge, and is an interesting challenge when you think about this is a challenge under a framework agreement in which Consultant Connect is not actually a supplier, so they're not part of the framework agreement, but they are challenging on the basis that they should have been awarded the contract, even though it was a legal impossibility under the framework agreement. So the courts are looking at this with our Regulation 18 hats on, so we're looking at it fairly, transparently, proportionately, ensuring that we're acting without detriment to anyone in the market, and we're not artificially narrowing competition down. And the courts actually agreed that there was a difficulty in this particular case, because even though Consultant Connect was not a party to the framework agreement, the fact that they'd been invited to this market engagement and been scored, and that the procurement would be designed in a way to avoid appointing Consultant Connect, that was a breach of the procurement regs, and that they were allowed to bring a challenge. And it's one of the rare instances where the courts actually said, well, yeah, damages are an adequate remedy, or damages should be awarded here because there is a genuine breach of the procurement regs. But interestingly for this case, and is very unique and very fact specific, the outcome, which is a shortening order. So the courts go, well, because of the services being delivered, we don't want to sort of stop the contract. We don't want to stop the sort of services and the members of the community being affected. So what we'll do is we'll limit down the contract that has been awarded, and that will give the contracting authorities time to then re-procure, but do it in a compliant manner. So it's quite an interesting case, really, and is quite an interesting case if you ever do market testing, is to be quite careful as to what our market testing looks like. Because if we are doing market testing and then we go, oh, we want this supplier, let's find a way to appoint that supplier, then clearly you are doing something that is against the general sort of procurement and competition rules, as currently drafted, at least. Next case, again, another one that is been around the legal updates, and that you've probably had presentations on before, is the Bromcom case, and this is a bit of an education related one, where we've got an education charity looking for some IT software for schools. We're looking at a 5-year contract here, which for £2 million is quite a chunky contract. And during the tender and submission process, the winning bidder did some things that were seen to be a bit against the ITT and against the procurement regime generally, which is that they uploaded their submission using a Dropbox mechanism. And I'm sure everyone is familiar with Dropbox, but just in case, there are other Dropbox entities out there, but basically is a cloud-based system where you can put files in that can instantaneously be viewed by another party, in this case the contracting authority. But what it does mean is there's not locked, and there's always the ability for the winning bidder to then update, review, amend, take out, add in submissions. So there was never a clear cut-off point for, well, here's our tender submission. There was always a potential for it to move. So that was a potential breach there. But the other breaches that will be a bit more interesting for how we design and evaluate procurements is that the evaluation process conducted by the contracting authority was to average across the scores. So we got evaluators given, a score of 4, a score of 5, a score of 4, and then instead of just going, well, we'll moderate the scores down and give them a score, which the ITT said, you get scored between 1 or 0 and 5. They ended up with decimal point scores, so 4.2 was awarded. And the ITT didn't allow for that decimalized sort of score to be added in. So there was a criteria in there that wasn't transparent, and the court, was looking at this as a breach of transparency there, which is that's not how the ITT was set up. There was no averaging scores there, and the gap between Bromcom and the winning bidder was so small that when you looked at some of these decimal points, they actually changed the outcome of the procurement process. So again, it's quite important. And then when we're looking at our equal treatment, I said at the very start, you will never be able to have a procurement process where you are re-procuring a service where, in my view at least, where there will be absolutely equal treatment to all. There will always be some benefit to the one who is already delivering the service. And in this instance, the winning bidder was already delivering the service across numerous education providers, and was able to say, well, if we win this contract, we'll drop our price on the other contracts, which again wasn't something that Bromcom could do. So they were scored and awarded something that was against the principle of equal treatment, essentially. And then the other bit, which is the bit that we all look at when we get sort of the questions. Once we've awarded our contract, we might get a letter saying, well, can you give us more detail? Why have we got this score? Why have they got that score? We think we should have been scored higher. They should have been scored lower. And we're always comforted by the fact that the courts, generally speaking, over numerous years, have been they've given quite a wide margin of appreciation to contracting authorities, to evaluators, to moderators, that only in the instance of manifest error will the court really open up and overturn a score that's been given. They don't really want to get into the facts of how an evaluator has evaluated a particular thing. Whereas in this instance, the court did go, well, it looks like there's at least 10 instances of manifest error here, of where the scores have been incorrectly given, either to Bromcom or to the winning bidder. And once you've corrected those instances, Bromcom was the actual outcome of the winner. So they should have actually won. So again, is an interesting case as to ensuring when we do set up our procurement processes and when we do set up our ITTs, we are quite clear as to how we are going to evaluate. So for example, if we're saying is 0 to 5, there's no average scoring, then we comply with that. Otherwise, it does open you up to a risk of a successful challenge and not sort of a frivolous, we're unhappy, we've not won. And also is to be careful to only evaluate what we've said we'd evaluate within the ITT structure. That's quite an obvious comment to make. But when you've got a contractor saying, well, we operate on another facility, we can offer you a financial discount there, do we take that into account? Well, the answer should be no. Unless there's a very fact-specific reason we can set out in the ITT that is clear to all that that's what we're doing. And even then, there's a good chance that it'd be subject to a successful challenge should it go to court. The next case I'll pick up on is the Med-equipped assistive technology case. So this was one of the biggest procurement processes of its kind. I think it was probably across Europe, where you've got 21 London local authorities all collaborating together on a sort of just shy of £400 million framework agreement for provision of community medical supplies, essentially. So things like mattresses, mobility assists, that sort of thing. And in this one, the question really was around the application to lift the automatic stay. So we've got somebody's awarded the contract, Medequip decide to challenge. We've not seen the outcome yet of the decision, but what we have seen is the court going, well, in this instance, we'll look at lifting the automatic stay. Is there a serious issue to be tried? Which is our first question. Well, Kensington and Chelsea sensibly say, well, yeah, there is a serious issue to be tried. So we move on to our next question. Is or are damages an adequate remedy for the challenging party if we don't lift the automatic suspension, or if we do? And the answer to that one was, well, actually, in this case, damages are not an adequate remedy for Medequip. And the reason why they weren't an adequate remedy was because there were some scoring criteria that were utilised and used, which weren't published. So it's difficult for the court to assess the quantification of what those damages would be. So because you can't assess the damages, the court decided, well, in theory, that means we can't decide whether damages would be adequate or not, because we don't know what they are. And it is impossible for us right now to decide what they are. So the court actually gets past are damages an adequate remedy stage. And then we end on the balance of convenience. And the court said, well, you've only just got past the damages an adequate remedy step, because there's an unquantifiable loss. But on the balance of convenience, we believe that the contract should be awarded and the stay should be lifted, which they did. And then because the stay was lifted, the concurrent application to expedite, so to say, well, if the stay isn't going to lift, we want the case moved forward and done in a shortened time frame, is, well, there's no need to expedite in the instance where damages, what we're saying is that the damages would be an adequate remedy. So it's an interesting decision there that should give some comfort that if you ever do get challenged and you are issuing an application to lift, that the courts are still applying in favour of the contracting authority, that once you procure these services, you need to get in the contract for a reason. So they are leaning more towards lifting the automatic suspension still than in favour of the sort of contracting, the contractor. Which moves us on nicely, really, to Camelot UK and the Gambling Commission case, which, as far as publications in the public domain goes, is still an ongoing case to some extent by IGT. Now, just as a bit of background, so we've got Camelot, who everyone would be aware of, hopefully, because they've been around for about 30 years now, delivering the lottery since, well, 1992, I think is when they first started. We're now on the 4th national lottery license, and the Gambling Commission decided this was the time to re-procure the process, and they did so in accordance with the concession contracts regulations. Now, it was a very long process by all accounts. Very expensive process to be run, as you can imagine. It's quite a hefty procurement. We're talking a serious chunk of money. Previous iterations of the lottery being challenged by judicial review, which I think Richard Branson did when he tried to run the lottery through Virgin. So we're in quite a heightened competitive tender here, where wherever the outcome is, the likely response is going to be a challenge to the award. And Camelot, who is the incumbent, would have potentially face significant advantage, would be the argument, for being the incumbent, but the contract was awarded to Alwyn. So we've got a new lottery provider. Was successful. Court claims get commenced left, right, and centre, looking at the case reports. And what we have at TCC stage, which is the case on the board, is we've got Camelot UK, we've got IGT. And IGT Technologies are a subcontractor of Camelot UK, and IGT brought their own case against the Gambling Commission on the basis that the procurement was running correctly. If it was run correctly, Camelot would have won. And if Camelot would have won, IGT would have been the subcontractor, which would have benefited from the process. Now, this opens up a significant number of doors to potential challengers for every procurement. If you think about it, every time you enter into any major procurement process, you award the contract to a contractor, you think in your heads, well, there's 5 other bidders, for example, only those 5 would have the ability to challenge us. Well, not anymore. each of those 5 might have 5 subcontractors of their own, and each of those subcontractors would be able to bring a claim. In theory, it's not yet been decided by court, but that is what IGT are pushing forward with from the press and from the case reports. The interesting bit about Camelot's case is Camelot is set up only to run the lottery. So when we come to our question of, well, can we lift the automatic suspension? So can the Gambling Commission enter into the lottery license with Alwyn to the exclusion of Camelot? Well, what the court looked at was, well, yeah, seriously should be tried. There's some potentially good legal arguments there. They decided, though, that damages would be an adequate remedy for Camelot. And that is quite an interesting question to ask, because Camelot are only set up to operate and run the UK lottery. So if Camelot don't win the UK lottery, they cease to exist. So the argument, looking at the case reports, is how can damages be an adequate remedy if Camelot are not in it for money? They're in it basically that's their whole purpose as a company. But the courts really boil down to what is the purpose of the competition, and the purpose of the competition was for Camelot to make money, and because the Camelot was trying to make money, the damages would be an adequate remedy. And again, this case doesn't set anything new yet, anyway, at least, but with this IGT question, it may. But what it does reinforce is that if we're running a competitive tendering process, the reason contractors are bidding is because they want to make money. So when we get to this question of automatic suspension and whether we can lift the automatic suspension, the courts are very much in favour of, well, you're only in it for money. So if your profit is £80 million, as long as the contracting authority goes, well, here's £80 million, I will put it in the court, so I'll give you an undertaking for it. If we ultimately failed and the procurement was messed up, and we breached the procurement regs, here's your £80 million, then the courts are likely to lift the automatic suspension. And even if there were doubts, the court would have gone on the balance of convenience. Now, something that isn't on the slides is that Camelot challenged the decision in the Court of Appeal to lift the automatic suspension. And so you've got TCC saying, yeah, lift, they need to enter into the license. You've got the Court of Appeal going, well, no, the procurement might not be run correctly, so you can't lift the automatic suspension until we've decided the appeal. So the Court of Appeal case, in effect, extended the challenge by a couple of months, and it looks like from the press is now being resolved out of court, and who knows what the agreement is. But the interesting bit from Colson in the Court of Appeal, Lord Justice Colson, is that even though the TCC say, well, yeah, we need to crack on with the procurement process, and the license, the lottery would be at jeopardy if we didn't, the Court of Appeal have the ability to basically stay that whilst they decide the American Cyanamides lifting the injunction tests. Just looking at time, we've got 5 minutes left. I'll just pick up one more case, which is the Churchill Gowns Limited and Stephen Gowns. I'm not sure if anyone, and again, this is one failing of webinars, we can't really get some audience interaction going, but when it comes to sort of procurement and use of gowns, it's always been Eden Ravenscroft for years and years and years. What we have in the Competitions Appeal Tribunal is we've got a new company, Churchill Gowns, and basically bringing a challenge that Eden Ravenscroft have monopolised the market and are basically unlawfully using that monopoly. And the court sort of held, well, no, they're not. They are just operating as a successful company. Now, what the inference is really is that you can't go after the person receiving all the contracts. You've got to go after the people who are giving out those contracts. So if you do have a contract in place with Eden Ravenscroft, for example, it may be the situation that if you ever did come to reprocure it, you'd be looking at a potential challenge, or if you fail to reprocure it, you might be looking at a potential challenge whether Churchill Gowns would do so. Is the age-old adage, why bite the hand that feeds you? But is an interesting one that might yet have some legs. We'll have to see where that one goes. There's some public procurement notes, which I believe are on LUPC's. There's a link on LUPC's website as well to these links, if any are of interest. But realistically, most of these will pop up in the new Procurement Act as well. So if there are any questions on the PPNs, I'm happy to deal with those. I appreciate it's sort of 3 minutes ago now, but I'm happy if anyone to email me any queries they've got on them. The one on the board now doesn't necessarily apply to higher education. It might apply to some other people on the calls who don't get caught as a higher education public authority, but it is best practice. So it might be one to consider. Again, it's one of those things I mentioned at the start of the call, really, which is the market is struggling. Material prices are fluctuating, and the sort of UK government are trying to figure out ways that they can try and drive best practice to try and secure the market and keep trade going and keep everyone profitable and stop companies going bust. This is one of the mechanisms they're trying to go down, and it's something that we saw during COVID with the PPNs, and it's something that we might see introduced into the new Procurement Act. So is one to watch out for. Is basically driving from best practice to law. So thank you very much. I'm not sure if there's any other questions.
There's just one question that just popped out, and I've not even had a chance to look at it. Has the final new SQ been published yet? One was published, but errors were found. Do you have any knowledge on that?
I don't know when it's going to be reissued. I've got no knowledge on when that's coming down the tracks, unfortunately. But yeah, I think generally the idea was that the go date was supposed to be June, 1st of June. So
Kathy says
it's got to be up.
Right.
Yeah, no problem.
I will be sharing the slides. Somebody just put that question in there. I will be sharing the slides. It takes us a little while to just sort of do the recording, or I'll put the slides out with the recording. If you get any questions on the screen, you've got Sam's information there if you want to interact with Capital Law on this or any other legal matter. And yeah, thank you very much indeed, Sam. That was very interesting, and I think we held everyone's attention throughout. It's a very good attendance today, so thanks very much everyone for attending, and hopefully we'll catch up with you soon. Thank you.
Thank you all.